Item number 10, approval of the minutes of the April 26, 2021 board meeting. Do I have a motion?
I move that we approve the minutes to the April 26 board meeting.
Do I have a second? Ms. Huddle seconds. Any discussion? And all
Ms.
those.
Hammond, I do have a question, I guess, is, do we need to approve the minutes of the May 4th board
Yeah, I'm gonna
meeting?
bring that
Oh, you
up.
are? Okay.
He's going to bring, yeah, because it wasn't in the minutes. But thank you, Ms. Huddle. So we'll approve this, and then I'll entertain that motion from you about the board. All those in favor of approval of the minutes of the April 26, 2021? And that was 6 to abstain. You were not in attendance. Thank you, Mr. White. Okay, Mr. Lovelace, I think we have some business you got to take care of.
Yeah, I was going to ask that we approve the minutes to the May 4th special call meeting. We brought it up and changed the agenda earlier.
Okay, and that'll be, it'll be.
And I make that motion. Okay.
And it'll be it'll be an information for the next time. Isn't that what we said? So people could read the minutes, or do?
The minutes will be published when the minutes to.
In the next meeting?
Next meeting,
Okay,
right.
that's all. I want to be sure. It was just inadvertently left out on this agenda. So thank you for, if you weren't here early.
You got to get a second now.
Do I have a second? Ms. Hines, seconds. No questions. Everybody understands it was just left out. All right, all those in favor of adding it? And that's 6 to Mr. White's abstain. He was not at that meeting. Action agenda number 11. Action is necessary and appropriate on matters discussed in executive session. Do you have F? Yeah.
The first item that we have on there is,
Field
let me
instruction.
put my glasses on, I'm sorry.
That's all right.
Selected employment items, Exhibit A for action. I make the motion that we approve the items as submitted.
Is there a second? Is there a second? Ms. Hines, any discussion? Seeing none, all those in favor of approving the selected employment items? And B is for information only.
And then I have another one.
You have another one, okay?
Okay, this is for motion for item number 11 on the school board agenda, which is pursuant to discussions in executive session, agenda items 3C, D, and E. I move that we give Kelly Educational Services Incorporated 30-day notice, termination notice under Article 11 of the contract dated July 1, 2018, and amended by extension on May 16, 2019.
Is there a second? Ms. Huddle seconds. Discussion.
As we are aware, we had some items that we discovered in our review of budget items that were we saw where there was overspending being done in the Kelly Services arena. We discussed this in executive session that we would look into their contract, and this is several meetings ago. We had a discussion by the administration at the last meeting, and after that we had to decide whether we wanted to what we wanted to do with the contract. So my motion is to terminate it and then to have an RFI, later for a rebid. RFP.
Did we need a date on that about how quickly we wanted to do it, Mr. Gant? I mean, Mr. Wow. That was a Freudian
the administration, I believe, could bring back the RFP. That's, if we give them the notice tonight, in 30 days, they could, our administration, while that's being done, could prepare the RFP, the request for proposals, and have that ready to go. So that would be, as soon after 30 days as possible.
And I say that for the staff, as we discussed, not having any anxiety of having something in place, but legal counsel told us that could get turned around very quickly. So, all those in favor of this motion? Yes, sure.
I just had a question, because we talked about this in executive session. Is this instead of or not, are we going to try to renegotiate the contract in this time, in this 30 days? Is that part of this motion, or is this motion to not renegotiate the contract?
My motion is that we terminate the contract and put it out, rebid it with with our CFO establishing the proper terms that we want to see in the contract.
I don't think your motion, though, addressed an RFP, so I have a motion to issue.
Do you want to amend this one, though, or you need?
I could do that.
Or you want to vote on this without an amendment?
I mean, there were two separate items on the agenda. There was a E. I think Mr. Lovelace is addressing C.
Which one are you addressing, Mr. Lovelace? D? Or were you putting,
Well, I'll restate my motion if that's okay.
Okay.
Okay, I'm sorry. Pursuant to discussions in executive session, amendment, agenda items 3C and 3D, I move that we give Kelly Services Incorporated 30-day termination notice under Article 11 of the contract dated July 11, 2018, and amended by extension May 16, 2019. And by doing that, I have taken agenda item 3E out, which Ms. Huddle wishes to address.
that's what you want? Okay, so we've had a motion, we had a second, and we've had any more discussion on that? All those in favor of Mr. Lovelace's motion, raise your hand. 1, 2, 3, 4, 5, 6, and that's 7, and no's opposed, no. So the motion carries. Thank you. Now, Ms. Huddle, on E.
Thank you. Addressing item 3E of executive session items, I move that our superintendent either issue an RFP for external services or develop an internal staffing plan to address the district's need for substitute teachers. This plan should ensure that such staffing is only used for substitute teachers and not to be used in lieu of permanent staffing. The plan should ensure that the daily rate for all substitute categories is increased to be comparable with other districts in the Midlands and include fixed daily rates for regular substitutes and a formula for flexible daily rate for long-term certified substitutes that are assigned to replace a specific teacher.
Okay. Is there a second? Mr. Lovelace seconds. Any discussion? Would you like to speak to your motion as to your purpose? Or you feel
Yes, it's to give the district the option. We discussed that perhaps some or portion of the substitute teacher needs could be filled internally. So we didn't want to say you have to do an RFP. So that's the first point. The second point is there is money, if you look at what we've already been spending, there is money to increase what we're paying as our base rate for our substitute teachers and make us more attractive for substitute teachers. And the reason the money is there is we've been paying some individuals or for some individuals some very high rates that may not have actually been teaching. They may have, and I don't want to say substitutes don't teach, but they may not have been the primary teacher in the classroom, or they may not have been teaching the subject material. So by pulling this in, we can raise the rate, the base rate for all of our substitutes and attract great substitute teachers and more of them.
Okay. All those, anybody else want to?
Ms. Huddle, I got a question for you since, I didn't just step on anybody, did I?
Mr. Lovelace,
Okay.
it's your turn.
Okay. Now, what about your motion talks about substitute teachers, does it not? Does it talk about permanent employees?
It says it won't be used to fill permanent slots. It does say that. Not to be used in lieu of permanent staffing.
So right now, we have some permanent staffing that's being paid through Kelly Services. How are we going to address, how would we address that? You think that addresses that in your motion?
I mean, that's for the board to discuss, but I personally don't think we should be hiring permanent staff through a substitute teaching contract. So, I'm not sure why we don't hire permanent staff as permanent staff, because we're paying 27 to 29% premium on this, and we might want advice from our attorney, but there are co-employment issues when you start paying temporary people as if they're treating them as if they're permanent.
Ms. Huddle, would you like Ms. White to address that,
Sure.
the legal?
Would you like to?
I certainly can. Thank you, Madam Chair, members of the board. There can be an issue if basically an employer is trying to get around the requirements of the labor laws, the federal labor laws, by treating employees as temporary employees rather than permanent employees in terms of access to benefits, retirement, and so forth. That can become an issue.
Okay, thank you. Any other questions?
Ms. White, can I ask you a question?
Certainly.
Mrs. White, you heard my question, Ms. Huddle, a minute ago. Okay, do you believe that would your legal advice be that we modify that motion in any way to?
No, I think the motion is clear. I think what you want to make sure is that the motion is clear to the administration, and I believe that it is. The only other point I would make is that during this 30-day notice period, this notice can be given tomorrow. Ms. Rawls can go ahead and give that notice to Kelly, and that during that 30-day window, that if the administration decides to send out an RFP, that can be done before those 30 calendar days expire.
Okay.
So that way the district is not in a situation that come August the 18th when school starts back, we don't know what we're doing as far as getting substitute teachers in.
Yeah, that's
And
right.
the other point I would make as far as the RFP is you can put in there that the district reserves the right to reject any and all proposals. So that would give the administration, if it's determined that it is less costly and more beneficial for the district to go in-house with substitute needs, that the administration could then come back to the board and say, we're going to recommend, instead of going with a staffing company, that we bring it back in-house. So you can have all those things going on at the same time, if that makes sense.
Okay, thank you.
Thank you. All right, item. Sure, Mr. White.
For Dr. Melton, is there a reason we were hiring permanent, were we hiring permanent positions through this temporary contract?
Dr. Turner, I'd like for you to come and answer that, please. There were some situations where we needed to fill some vacancies, and Dr. Turner, I would prefer that you speak. Of course, confidentiality has to be maintained where you can't share certain details, but for the board and for the public to hear, how could you answer that question?
All of our vacancies are filled with actual employees employed by the district. We do have subs that have been brought in addition to those, but all of our vacancies are actually filled by actual employees of the district.
Is that?
So the motion your motion excluded permanent workers from coming through. Was there an indication somebody was doing that?
Yeah, there's 2 positions in the district office that are not teachers that are on that Kelly Services invoice, and they've been on there for a very long time, 5 days a week for years, like 2 years, I think, since 2018. Am I incorrect on that? There are 2 positions, people that are not teachers that work in the district office that are on that Kelly Services bill and have been 5 days a week, 52 weeks, I think 52, but for years.
I want to make sure we're using the same semantics. I want to make sure we're talking about the same thing. If asked, are there subs that are in vacancies? The answer is no. Those employees of Kelly Services that you're referring to, they're not in district vacancies. The district has hired for those positions. Those employees were brought in on a temporary as-needed basis, and they have been there for a while. And they are employed through Kelly Services on an as-needed basis, but they are not holding actual positions that have gone unfilled.
But you agreed those positions were not teacher vacancies.
Yes, those positions were not teacher vacancies.
And you
yes.
agreed those 2 people we were billed for those 2 people pretty much 5 days a week, every week since 2018.
Yes, we do have subs that are not
Not
teachers that we
subs,
pay
these two
for.
positions.
Yes, those
Okay.
two in addition to several others, yes.
So I mean, I'm curious, my question was, do we have that? And it sounds like we did, and is there any reason why we had to have it that way? And does this resolution interfere with anything? I mean, what is the impact of this resolution?
I don't know of an impact that would have the resolution, I don't think in a negative way. Without us going into confidentiality of personnel situations, there have been employees that have been hired that have needed someone with some organizational history and have had interest with continuing on for the support. So that's been one component that I'm aware of. Dr. Turner, from your perspective, what else might you be able to answer or add to that to bring context?
Based on the historical data that I've been asked to review at the board's request, my understanding is that those two employees were brought in supportive, as-needed terms, and that's as far as I was able to go based on historical data. They were for support and training in that department.
But Mr. White, to answer your question, I don't think that the resolution is going to create a problem because it has helped us with the window of time that we've operated within. We should be ready for capacity and success moving forward. Dr. Turner, is that a fair assessment?
That's what I've researched. Based on what I've researched, I would say that that is accurate.
Thank you, Dr. Turner. Any other questions? We'll vote on Ms. Huddle's motion. All those in favor? All right, and that is 7, no opposed, and that passes. Item F. Have we done that? The late hour? You need Mr. Beatonbaugh. Item F. I'll entertain a motion for F, the building.
I'd like to make a motion that for item F, considered in executive session, building structure at 6020 Westcott Road, Exhibit D. I make the motion that we approve the administration's recommendation.
Mr. Beatonbaugh, you want to, I'm going to let him, did you need him to help you, though, with the wording? You just couldn't say to? No, I just made the motion. Okay. I do. I just needed you to finish. I wasn't sure that you explained it all the way, but that's okay. We'll take that motion. Is there a second? Yes. And then we'll have it explained. You want to let Mr. Beatonbaugh, or would you like to answer it, Mr. Lovelace?
Mr. Superintendent Melton, this is.
I don't know that we needed further explanation. If Mr. Lovelace, with the motion that you had, I don't know that was there a second, though? I missed that.
Yeah, we got the second.
There's a second?
Ms. Hines,
Okay, Ms.
second.
Hines, second. So unless there's something that the board would like to have during discussion for clarification, there is no presentation for the public.
I just wanted to be sure this building that they understand it's just permission to sell the building and not the land. So I just thought that needed to be clear.
Yes, ma'am. It's the building structure, as Mr. Lovelace.
Yes, you can.
Mr. Beatonbaugh, as I understand it, this is an old house and a barn that's owned some existing property that the district owns, and that property is abandoned and in dilapidated form, and that the district is asking to sell the house and the barn, and remove it from the property. Is that getting proposals to do that?
Yes, sir, that's correct, Mr. Lovelace. Thank you.
All right, and I think the board understands that. I just really wanted the public to understand it because they weren't privy to the details. All right, all those in favor of giving the administration the authority to sell that actual building? And that is 7. And Mr. White, did you vote yes? You did, okay. So, I just didn't see your hand. And no opposed, so that passes. The building structure at 6020 Westcott Road that'll get handled. We're back to G, which is our actual last one out of the executive session. Legal advice related to threatened litigation against the district. Before we start, I do want to say a couple of things. In hindsight, I certainly regret not having legal counsel present at the May 4th meeting, it could have avoided a large amount of confusion. Advice was given to me as chair and to Dr. Melton of threat of legal action. Another lawyer had actually called our lawyer, so I feel like the decision to allow Dr. Melton to make operational decisions, realizing the board would be together by tonight where we could make, something that would actually be a policy of mask. And instead of me trying to explain it, I'm going to let Ms. White, before we entertain any motions and discussion, for you to explain how you explained the meeting of the 4th and what we deleted, but that we did not have a mask policy in place. So I'm going to let you explain it.
Before I do that, just I see that Ms. Gardner has her hand raised.
Yes, ma'am. Well, I'm going to have your motion, but I want her to explain for me. Yeah. No, we can ask her any questions after your motion. What I am asking as chair, because there have been a lot of accusations, and I'm certainly against tyranny. I teach social studies, so I believe in all those people that talked about it. So I want, as chair, it's important to me, just for this point that's been made, before we have any motions, about Dr. Melton and myself. We did talk with you, and I just want you to tell us what your recommendations were to us and why.
Madam Chair, members of the board, and members of the public who are here this evening, I was not at the May 4th meeting, and I was not consulted prior to the May 4th meeting about the action that the board intended to take. I have worked with this district in one capacity or another for the past 30 years as an attorney in Columbia. I received a phone call on Wednesday morning from an attorney who represents the South Carolina Education Association, informing me that he had been contacted by the SCEA and was representing somewhere in excess of 100 employees, and that they planned to file, that group of employees planned to file a lawsuit against the district immediately. And that they would be seeking an injunction. What an injunction does is to basically maintain the status quo, which would have been keeping in place policy ADD that would have been repealed, or that was repealed as a result of the action of the board on May the 4th. In response to that telephone call from this attorney, I have a duty as an attorney to advise my client of threatened litigation. So I sent Ms. Hammond a text and said, I need you to contact me immediately so that I can advise you of this telephone call that I have received. Dr. Melton and 2 members of her staff had also asked that I participate in a conference call with them at noon on Wednesday. When I was asked to participate in the conference call, I didn't know what the subject was, but after I got the phone call from the attorney, I figured that must be what the subject was, that it was about the situation with the repeal of the mask policy. What I explained to Ms. Hammond and what I explained to the administration was that while the board had repealed policy ADD, which certainly is within the purview of the board to do that, to repeal policies that it has enacted, that there were still State Department of Education guidelines that had been issued in August of 2020, and that those guidelines were still in effect. And that until I had an opportunity to discuss the impact of the existence of those guidelines with the entire board, that it was my advice that the district continue, or that the district follow this Department of Ed guidelines. The reason that I provided that advice to Ms. Hammond and to Dr. Melton was because there is a joint resolution that was passed. It was actually passed in April of this year, which states that school districts, as a political subdivision of the state, along with other businesses and public entities, there is immunity from any lawsuit that is filed against a political subdivision like a school district, or again, any state agency, private business, so long as that entity, in this case, the school district, is substantially adhering to public health guidelines. And it includes within that not just guidelines issued by DHEP, but guidelines issued by other state agencies, which would include the Department of Education. So just to explain all this, neither the chair nor the superintendent did anything that negated what the board had done. The board did not address, when they met on May the 4th, they did not address the impact of the State Department of Education guidelines. Had I been there at the May 4th meeting, I would have discussed that with the board at that time. And then the board could have decided what they wanted to do. I don't control anything that this board does. I simply provide advice, and my clients, I represent school districts all over the state, and my clients can accept my advice or they can choose not to accept my advice. So, you know, I had hoped that and had expressed to Ms. Hammond that I wanted to have a special called meeting on Thursday or Friday so that I could talk with the school district about the implications of the repeal of policy ADD and the existence of these guidelines, but I was informed by Ms. Hammond that a special called meeting could not happen based on the inability of a number of board members to be able to attend. So that is why we are where we are today. For the board, now having heard from me in executive session about what it means if we don't follow those guidelines and what could happen if we don't follow those guidelines, now the board is prepared to take some action tonight that the board believes is in the best interest of all the stakeholders within the school district. So that's how I became involved and the advice that I provided.
Is your question to her, because I'm gonna
Yes.
start the motion? Okay.
Yeah, I wanna-
But while she's up there, okay.
Yeah, before a motion's made, I want to ask her a couple questions. And this is an important point when we talk about immunity and lawsuits. And I think I'm going to preface this in what I'm hearing, but I want to ask you to explain what immunity means, what it means in the cost of a lawsuit, and what these type of actions. I mean, we're in a pandemic. It's a new. It's an unknown what sort of liability claims people will make against any organization, including the school district. And so can you explain what it means when a statute says we have immunity, what that means in terms of the legal spend that this district would have? And if we didn't maintain that immunity, what that means, and whether or not there's a clear pathway that we're covered by insurance without the immunity.
Immunity means that in the event, if this school district is substantially complying with the guidelines that have been issued by the State Department of Education, which is what the immunity provision says, that if the school district is sued in response to that lawsuit, we point to the immunity statute. And so we would be asking a judge to throw that lawsuit out, okay? It's called a 12B6 motion for failure to state a claim because we have immunity under the statute. And we would, as part of that, be asked to present to the court how we have substantially complied with the guidelines that have been issued by the State Department of Education and approved by the State Board of Education. So what I'm saying is, if we have that immunity, if we have the benefit of that immunity, then the lawsuit is thrown out by a judge before we get into the expenses associated with a lawsuit, such as depositions, written discovery, and a potential trial. If we do not have that immunity, and the district is sued, then what will happen, and let me explain the difference between injunctive relief and the seeking of monetary damages. What I was advised by the attorney for these employees is that they would be seeking injunctive relief. What that means, as I explained a little bit earlier, is that they would be asking a judge to maintain the status quo by reinstituting policy ADD. If that is the lawsuit and they're not seeking monetary damages, it's just simply an injunction order, then it's very unlikely that the school district's insurance, that your liability insurance would pick up coverage for those kinds of claims. Your insurance policy provides coverage where the plaintiff, in this case a group of employees, is seeking monetary damages. So that means that the district would then have to pay to defend those lawsuits through the general fund. So those monies would be coming straight from the general fund to pay attorneys to defend against those lawsuits. If lawsuits are filed where the plaintiff is seeking monetary damages, then those lawsuits, again, I'm talking here in generalities because until we actually see a complaint and see what the causes of action are, I can't speak definitively that insurance would or would not cover it. But generally, in cases where a plaintiff is seeking money from the school district, those kinds of cases are covered by the school district's insurance company. And right now, y'all are insured through the South Carolina School Board's Insurance Trust. So not only would the trust pay the cost for attorneys to defend against that lawsuit, but they also would pay the cost of any settlement or the cost of any award. Now, I will say that if individuals are sued, if it's not just the entity, the school district, the trust may defend those suits with what's known as a reservation of rights. Basically meaning that if, whether it's an administrator or a school board member, whoever is named as the defendant in that lawsuit, that the trust reserves their right if that person is found to have acted outside of their scope of authority as a board member, then they may be, the school board's trust may say, we're not going to defend you anymore, and if there is an award of money against you, it's on that individual to cover the cost of that, as opposed to the insurance company.
So if I can sort of distill that, there's not 100% certainty, even with, with injunctive relief, we're not going to be covered, but an immunity statute would cover us and dismiss that lawsuit very quickly with little expense to the district. If there's a monetary suit, then it's not 100% certainty that insurance would cover it, but even if somebody claims even these people sitting at this table acted outside of the scope of their positions here, then there may be liability to the district and there may be liability to the individuals, and it may not be covered by insurance. But if we stay within the immunity statute, all that is still protected.
That's correct.
Okay, thank you. Ms. Settle.
I have a couple questions. First, I appreciate the advice. I would really like to understand exactly how an email went out on May 6th at 6:18 p.m. that said that the Lexington-Richland School District 5 Board of Trustees has been advised by our attorney. So I have a couple questions. Who did you advise before May 6th at 6:18 p.m.?
I advised Superintendent Melton and I advised Chairperson Jan Hammond.
Okay. Did you review this statement before it was emailed out?
Yes, it was prepared by the administration. It was sent to me and I reviewed it and edited it. Let me also say that I advised both Dr. Melton and Ms. Chair and Ms. Hammond that they should contact all of the other trustees. That's not something that I do as the attorney for the school district. My communications are with the superintendent and the board chair. And so I provided that advice to both of them that they should contact the rest of the board of trustees, because we weren't, at that point in time, I had been told by Ms. Hammond we can't have a special called meeting, correct? So that's when I said, advise the board members of what is getting ready to happen.
Anybody have a motion?
I have questions.
Certainly.
So, first of all, I'm going to just go ahead and express a little bit of concern that we're having this conversation. I feel like some of our legal advice that you gave us back there, you're having out in public, so we've just waived that privilege with counsel. And it is what it is at this point. My questions they echo on Mr. White's questions a little bit about this Senate Bill 147 and the immunity that it provides. My question regarding that is that legislation covers, I feel like what I'm hearing in the news from different school entities from you is that it's talking directly about schools, and it's not. That bill covers, a covered entity that is not a for-profit or nonprofit business it covers any government entity, municipality, county, any other government entity, like I said. There are several counties in South Carolina that never had a mask mandate. There are several municipalities that never had a mask mandate. There are
several of each that have allowed their mask mandates to sunset. Are you saying that now all of the counties, all of the municipalities, every school district in the state is now opening themselves up as under this legislation? I'm asking because when I read this legislation and it says when you're immunity from liability, it says that a covered entity is a covered entity is anyone that reasonably adheres to public health guidance applicable at the time giving rise to the coronavirus. So when I read this, I see the word reasonable. And I know that many municipalities and many businesses and many counties and this school district say that you should strongly encourage the wearing of masks. That's what the guidelines say, that's what the CDC says, that there isn't a mandate, and that is the difference here. It's not saying that a mandate is unreasonable, it's saying follow the reasonable guidance. And so we're getting a little bit lost in this, and we made a motion, you're our attorney, I'm just trying to see, I feel like we're getting one set of advice, like one path of advice, and I would like to see both. I don't know that this is the appropriate forum for that. And I'm also concerned that we're just saying that this legislation is impacting schools because it's convenient to say that it's impacting schools, but we're covering so many other entities in South Carolina. I've spoken to people that have been involved in this resolution, and that word reasonable means a lot. I mean, I guess I'm concerned with that, and also I'm concerned with the fact that we did have, you said in an executive session, since we're talking about that the State Department of Education's policy guidelines, that they are just that, they are guidelines. We are not bound by the Department of Education's guidelines. And so the fact that we allowed our policy that we set, or the repeal of our policy last week, to be overturned by an email, whoever it was from, is very concerning to our community because it makes it, and I appreciate that you have tried to clarify where that came from. I'm just saying that is confusing. It undermines our board, and it makes it seem like when we take a vote, it doesn't matter. And wherever you stand, whatever your position is on this mask, on mask or anything, we can't allow that to happen. And so I'm just putting that out there.
Well, and I'm not sure, Ms. Hines, if that's a question or just a statement, but I would like to say that as far as S-147, it mentions, it's broad as far as the coverage of entities that are part of it. Political subdivisions, a school district is a political subdivision of the state. Right. So it does cover school districts, but no, school districts are not the only entity that get the protection of S-147. Ultimately, who's going to decide whether or not there was reasonable adherence to public health guidelines is going to be a judge and or a jury. That's who's going to make that decision. So, as far as what other counties, municipalities, other political subdivisions are doing, I assume they're consulting with their attorneys about that, but ultimately that's going to be who decides it. As far as you are correct that what the department put in place in August of 2020 is not a mandate. It is not a state law. It is not a regulation. It is a guideline. I can tell you from personal experience from a case a number of years ago where a judge ruled that guidelines, whether or not, and it in fact was the school district, whether or not the school district complied with guidelines, federal guidelines that had been issued, that the plaintiff in that case could argue that the school district's failure to comply with those guidelines was evidence of negligence. So that is the impact, that's the impact of the guidelines. Right. And the last thing I will say is that the board, I asked and had Ms. Goggins send me a video of the board meeting so I could see whether or not the board had addressed the existence of the State Department of Education guidelines. That was not, in my viewing of that video and my conversations with Ms. Hammond and with Dr. Melton, that question was not answered. There was no consideration of the guidelines. So, you know, I just have to respectfully say that I disagree with your characterization of it as undoing what the board had done. The board repealed policy ADD. The board did not vote not to follow the guidelines or direct the administration not to follow those guidelines, which is why there was confusion. And I believe Dr. Melton said that she needed to consult with legal counsel to determine what the impact was of the board's repeal of policy ADD.
Thank you. Any other questions before we start entertaining?
I do have a question.
Okay.
And I would just like to add, you know, Ms. Hines, the nomenclature. Obviously, I didn't attend the meeting. I saw some of the noise and chatter and stuff that was coming out. I don't perceive it as being overturned either. I think the way it was presented and communicated, from my perspective, it was put on pause for a very good reason for us to have this kind of conversation. And I don't think we talked about attorney-client privilege. I asked her to explain the distinctions between immunity in a statute and coverage of insurance. Those are just facts. I mean, that's not, I don't think we talked about privilege. I don't think you would talk about, I think you're schooled enough you wouldn't talk about privilege stuff.
Right.
But that was a distinction that when I hear as much of the public saying we overturned, y'all, that you overturned and vetoed and all that, that's the wrong nomenclature. It was put on pause, but there was a piece missing. There was a piece that y'all did not address, and it was very prudent for these two to have addressed it. I know there's some friction about the way and all that, but when you step back from all this, the real question that I'm concerned about sitting here is, are we unnecessarily exposing our assets? And I do have a question here, but I want to add one more comment. What everybody else is doing, there's an old, I hear people say this occasionally, it's never an excuse under the law when you say somebody else is doing it. It's kind of like everybody speeds, but when you get pulled over, you're the one that's going to get the ticket. If we get sued, we maybe get the one that gets our, that gets the legal fees that we have to pay. And some of these other institutions, governmental bodies, it may never happen, or it may happen worse. But my question for you is, I heard three things here as far as a standard. You said the immunity statute says substantially adhere. I think, Ms. Hines, you said reasonably adhere, and then I'm hearing other people say strongly encourage. What is the most directly connected phrase to what this immunity statute says? Because that's the easiest way we'd avoid a debate, because if we lose an argument that we complied, then we may be spending money that we shouldn't be spending.
What I'll do, Mr. White, is to read from the joint resolution itself. It states in the preamble that to enact the COVID-19 Liability Immunity Act to provide liability protections for a limited time period for healthcare providers and businesses that follow public health guidance in response to the coronavirus public health emergency. Then when you read on into the resolution, it defines all the entities, covered entities, and that's when it talks about government agencies, divisions, political subdivisions, and so forth. The resolution then states that notwithstanding any other provision of law, a covered entity or covered individual that reasonably adheres to public health guidance applicable at the time of the conduct giving rise to a coronavirus claim shall be entitled to immunity from liability for any acts or omissions resulting in a coronavirus claim. And again, and who decides whether or not there is reasonable adherence? As I said earlier, that's going to be a judge or a jury who's considering the coronavirus claim.
Ms. Huddle?
I have one other question. If the board voted to repeal another policy, let's just pick one, fiscal accounting and audits, would that automatically mean that some guideline from some obscure agency would apply?
No, it would not. In this particular case, by virtue of the fact that the guidelines were not addressed and we've got the immunity statute in place, the significance of not following those guidelines were such. But no, if y'all were to repeal some other policy that did not have the same legal implications, the fact that there might be some guidelines out there, that would be something to discuss at some point in time, but it wouldn't have the urgency of this situation when we have been threatened with 100 lawsuits.
I'm not saying it's not important.
Right,
I'm
I
just
agree with you.
saying that, and I was on the other side of this issue, to be perfectly blunt, but I do feel that the will of the board was not held up. And to say that because there's some guideline out there somewhere that when we repeal the policies, it means this guideline now takes effect without the board saying so, I think is disingenuous and not true. I mean, I'm not a lawyer, but it just doesn't make any sense to me. I'm not saying that what the issue you raised wasn't important. It was. But I do believe that the will of this board was overturned, and it disturbs me.
Mr. Lovelace?
Was the intent from, I mean, or do you know, I guess nobody really knows this, but from the South Carolina Board of Education, was the intent for their guidelines to be a replacement for those districts that didn't have policy or supplement the ones that did? Do you know that?
I can't speak to that. You'd have to go back and look at where the state board considered the guidelines and spoke to the guidelines. So I can tell you from my personal knowledge about the districts with whom I work, that the majority of districts did not adopt face covering policies. They followed the Department of Education guidelines.
So a lot, I mean, just from, I know it's anecdotal because you don't have a census of all the districts, but the ones you represent, they looked at the policy and the guidelines and used that in place of an individual policy from their school board.
Correct.
Okay, so that precedent is out there where people have done that. So,
It is.
okay, thank you.
Ms. Garner?
Is it possible if we put a policy in place tonight that mandated a mask for the whole district? I know we've had the threat of certain individuals threatening for an injunction for us to remove masks. Would that same possibility be in place if, say, a group of people who wanted to unmask for we've heard lots of reasons tonight, could they get together in a group of people and also do an injunction against the school district for making our children mask? Is that a possibility?
That is a possibility.
So it can go either way?
Correct.
Okay, so my next question is, for someone, so the injunctions are there whether we mask or unmask. Possibly. There's a possibility. We've been threatened. My next question is, though, for someone to actually sue for damages, they would have to, sometime when we weren't following policy guidelines and didn't have a policy, they would have to get sick, prove that it was contact traced through the school district, and have something very detrimental happen to them so that there would be damages that they would need to have restored to them. And that would all have to happen I'm just going to say this, in a school district that has no cases in the next 40 days. So that's the possibility. Our range of liability is 40 days for that. I'm just trying to clarify.
Yeah, that is correct. A plaintiff who was claiming that either they themselves or their child contracted COVID while at school, they would have the burden of proving that they contracted it at school.
And it would have
Correct.
to be after, like, say today, because the policy was officially repealed today, it would have to start from now. So it's a future thing.
Correct.
So-
That they would have to, what they would have to do is link it to the district's repeal of policy ADD and not following the State Department of Education guidelines, and prove that they actually contracted COVID within the school building as the result of their attending school, which in my opinion is a high standard of proof. As far as damages, there are medical damages as a result of bodily injury. There are also psychological damages that can be claimed, so we could see something like that as well. I mean, and I think Mr. Lovelace said this, we're in uncharted territory right now. This has become such a it's a divisive issue, and it's also an issue that's uncharted, in terms of what kind of lawsuits are we going to see? Are we going to see any lawsuits? What are going to be the theories of liability? That's what becomes so important is, you've got your plain old negligence claim that the school district was negligent in failing to protect my child. Now my child has COVID, right? You've also got the possibility of the parents who wish to have their child not wear a mask to school, that they would file some cause of action against the school district, right? And come up with some theory of liability. We just simply, until we see any complaints that might be filed, I cannot provide you advice on what do I think about the strength of that claim, because I don't know what the claims might be. I know what a negligence claim would be, right, because that's something we deal with all the time, that a school district failed to supervise students, it failed to protect students. Those are what I would call more common kinds of claims, and I'm talking about like a fight on the playground or something that happens in the lunchroom where a parent falls on, something on the floor and files an action against the school district. But these kinds of claims, again, we don't know what are the different theories of liability that are going to be raised. And that's the case with the employees who have threatened to sue, as well as the parents.
Well, and just one final question. So if we had not repealed the policy, but someone did get sick and require damages because they were an athlete of some sort, because I'm here to tell you our athletes are not masking while they're practicing or while they're on the field, or even the spectators at half of the stuff going on are not being masked. They're not masking. I can say that firsthand because I've seen it. Wouldn't we be liable with a full policy that we weren't following? Wouldn't that still be an issue?
That could be an issue, yes. Even if you have the policy in place and it's not being enforced, then if I was representing a student and their parent against the school district, that is what I would raise. I would say, well, you've got a policy in place, that's great. You're not adequately enforcing that policy, and as a result, my child became ill.
Thank you.
Ms. White, do you mind sharing, it kind of goes to Ms. Gardner's conversation, would you share with everyone on the board, when you called me, say the 100, I know that you told me the lawyer was saying if we did not act immediately, that this was going to be the lawsuits brought against us, and I know you mentioned the 100 people. What would be, since you did talk to the lawyer, what was the actual thing we would be accused of?
I don't want at this point, we're getting into attorney-client privileged information now about the basis of any claims, and I'm not comfortable doing that publicly.
All right, I guess what I'm trying to say is, I guess we were looking at what either side could sue. I mean, you could be in the middle of this conversation. It could go either way. But I think, I definitely voted to delete policy ADD because my conviction is, and I'm a teacher, I think masks are not, they really don't do what the CDC thinks they do. And I thought that our policy needed to be deleted because it was not clear. I thought it was cumbersome. I heard how every teacher kind of interpreted it different. So, I voted for that. But and then when I realized we could possibly be sued and the chaos we were causing, I felt like, and then it was like that, hurry up, we're going to be, there's lots of trouble here. And I thought I was protecting not only the board, but mainly the district and the students and the money. If we're told there's for sure going to be the lawsuit, it wasn't a maybe, it was we're going to have it. So I'm glad tonight that we can now start with any kind of mask policy that you guys want to bring up, and we can discuss it. And I think Mr. Hogan wants to speak, though, and then I'll come back to you, Ms. Gardner.
Ms. White, in your legal opinion, would we have immunity under S-147 if our policy strongly encouraged in lieu of mandating?
Again, what I can say is that ultimately the decision of whether we were reasonably adhering to that is going to be made by a judge and a jury. Okay, I would certainly argue that, but again, there's the uncertainty of who's going to make that decision. And it depends on what judge you get in front of. It depends on who's on that jury as far as a determination of that.
Okay. So follow up to that, in your opinion, let me take that back, sorry, not in your opinion. The word mandate in itself, is that something that can be perceived as a slippery slope as far as overreach? And putting us in a position as a board of 7 individuals essentially making things happen?
As far as the word mandate, I don't think that's not a word that is in the Department of Ed guidelines. It clearly says that they are guidelines, but then when you read through them, it says student shall, right? But they're not terming it as a mandate from the State Department of Education. And again, could it happen that somebody sued the Department of Education for governmental overreach? That could happen as well, yes.
All right.
Okay.
Last question I had more
Sure.
for the district. So we are tracking data and we're looking at everything that's being brought to us, but, and I understand I'm going to hit you all with a question you're probably not prepared for, but does the district have the data that we can extrapolate relatively accurately that lets us know the effectiveness of these masks as far as a close quarter contact with a quarantine and the number of percentages that we have that are out in quarantine for a week that come back with a positive test that are not, in fact, COVID positive? I mean, looking at the dashboard now, we've got 57 quarantine students. That's 57 kids that are out of school right now as a result of 2 positive student cases. So I guess my question is, we're having this detailed conversation about mandating masks. Do we have the data that justifies?
And that's
The
not a question
decisions.
that's not a question that I can answer. So
Yeah,
I would
I'm sorry, that
defer.
was more directed towards Dr. Melton.
And Mr. Hogan, I don't know that we have a way of measuring that. The dashboard is the information that we have, but I don't know that how we would tease that out without going through each scenario, but, so to answer your question, no, we would not have a metric readily available with an answer to your question with confidence.
Okay. So with a quarantine case and a positive case, is the way that we keep track of everything, is it the same box that's checked for that excused absence?
Dr. Harris, I'd like for you to come forward, and I'm sorry, he's got the microphone trying to exchange the batteries.
We caught you.
My apologies. Mr. Hogan, can you ask that question once again for Dr. Harris to hear? When it comes to an absence, of how we are tracking absences, I think I heard you.
Yeah, and I can probably give you like a firsthand experience. So of course, my kids have been quarantined multiple times and with positive cases as well. Over that 21-day span where they were in quarantine, does their absentee record show the same reason for their absence for all 21 days, even though they weren't technically positive for 21 straight days, they were quarantined for close quarter contact? Again, I'm trying to figure out, can we extrapolate this data?
Well, I think at the beginning, Dr. Harris, at first, we were taking the guidance from CDC and the number of days of quarantine. We were able to condense those numbers as we got further into this and more information came out. Dr. Harris, I don't know if you would have the confidence to answer Mr. Hogan's question if we had that data readily available.
I certainly do not have it readily available. And I'll be quite honest with you, Ms. Hogan, I would really prefer to, if at all possible, to respond to you and write into that question, because I want to make sure that I want to gain
absolutely.
even more clarity in what it is you're asking, because I see it from 2 or 3 different perspectives, and I'm not sure which of those that you are desirous of. So if I might, I would certainly like to respond to you.
Perfectly fair. No, if it's all right with you, I'd like to just email and kind of outline what I'm looking
be
for and
perfect.
see if it's something that we can provide.
Certainly.
Thank you.
Ms. Gardner, she has one question.
I just
Is
have
that
one
all
more
right?
question.
Ms. Hines?
Real fast. Can you Dr. Melton or someone from your staff emphasize all of the mitigation factors that you are still employing to make sure that our schools are safe, and your guidelines for sanitizing and things like that, minimizing the impact of coronavirus outside of the masks?
Mr. Cannon, if you could come forward first. Is Mr. Cannon still here? He is not, okay. Dr. Harris, could you assist with answering, or Nurse Stanek, I see you over next to the wall. If you could assist with answering the mitigation we're currently doing, and of course, every site's going to be a little different depending on the size and the number of students, but overall, what could we say that we're expecting for all facilities, regardless of size, Dr. Harris or Ms. Stanek?
Thank you. I'll take a stab at that, and I do appreciate the opportunity for Nurse Stanek to offer a comment, and quite frankly, maybe Mr. Beebo may have some comment in terms of operations as well. We do continue to ensure the social distancing as a safety measure. That does look differently in various schools and in some of the different classrooms. We do maintain the hand sanitizers that are available throughout our schools. I think Mr. Beedmo would also kind of talk a little bit about cafeteria, which I think is important as well, because there are some standards there that need to continue to be met. I'm going to yield to Nurse Stanton to just kind of talk about from the health room perspective and the contact tracing to kind of speak to that also.
Okay, so mitigation procedures, one of the things we're doing, you've already mentioned quarantines. So we continue to quarantine those that are close contacts. Something to know about that is that recently there was guidance, there was change to the guidance that if both students are wearing a mask, we can bring that close contact down to 3 feet. So that has allowed us to cut back a little bit on the number of students that need to be quarantined according to the definition of a close contact. So if you're in a high school and your only contact is one class period and you were both wearing a mask, and it used to be 6 feet, now it's 3. So that has helped. So quarantining is something we're still doing, and we social distance every chance we get as much as possible, but with all the students back, that's not always possible.
What about the sanitation part of the schools?
I'm going to ask Mr. Beanbo to speak to that. Mr. Cannon has stepped out. Mr. Beanbo, as far as operations for sanitation of buses, of the facility, and then, of course, inclusive of cafeteria, what could you share that's happening in all sites?
Yes, ma'am. Of course, on the buses, because they are Department of Education on buses, we're still wearing masks on the bus to and from school. We're able to maintain 3 feet distancing in our classrooms. We've reduced that to 6 feet. We are still rotating classes in and out of the cafeteria. Some folks are still eating in their classrooms, and we're trying to maintain 6 feet distance in the cafeterias when kids eat. And we've also have increased and still have increased the number of lunches in schools where they come to the cafeterias. So our custodial staff is still cleaning the classrooms. Our teachers are leaving at a reasonable time, and we're still cleaning every night after school. Thank you.
That's a good place that I'd like to plug the great work that all custodians are doing. I know in this school, in a different district, I applaud them, and I know ours are working that same hard work because they're on top of it. I had a question. This, Dr. Milton, this may be with you, or you may have this data. Do we know the percentage, or maybe Dr. Turner, of our teachers that have, because I know it's been offered, and we set up times that they could leave school and be sure they got it. Do we know the percentage of teachers in District 5 that have gotten both vaccines, or one, whichever one they took?
No, ma'am, we do not have that data. I can say that we had nearly 700 participate with the events that School District 5 offered in partnership with Lexington Medical, but we saw a decline between the number that enrolled and the number that participated. We could assume that some of that happened because people were able to accelerate their own options to get the vaccine, of course, when Johnson & Johnson came out with 1 rather than 2, but we do not have a way of tracking that. That is not required. If you look at a TB test, we of course require that statewide. That is required, but something like this, it is not required that staff present that information because that's considered to be medical information.
I was asking the question because as we're debating mask or no mask, I know we heard from teachers how, they have concern. There are teachers with health concerns, and so I was just hoping that we had a large percentage of ours that have gotten the shot. And I know it is by choice. Any other question till we entertain any motions? And then we'll probably have some more discussion. Ms. Gardner.
To reasonably adhere to state school board guidelines and to clarify District 5's position on masks, and to provide students, staff, and parents choice, I move that we approve for discussion first and second reading a new board policy, ADD, face covering, that I provided to each board member just before this meeting.
Is there a second? Okay, Ms. Hines. Would you like to speak to your motion, Ms. Gardner?
Yes. I'd like to probably just explain it if you haven't had a chance to read the whole thing. It's very much like the previous policy, ADD, that we had that we repealed, with some very key features. It does not, when you get to the staff members, it only strongly encourages them to wear face masks. It does not mandate it. It doesn't say shall, it says strongly encourage. And then when it gets to students, it says that face coverings are encouraged to be worn by all students and teachers when entering and exiting school buildings, while in the hallways and common areas, and while in close proximity to others. So it's encouraged. And then it says students and staff may remove their face coverings in the classroom while social distancing and while outside. It's still an encouragement, it's not a mandate. And then there are some exemption protocols like eating, just not being able to take care of yourself or be able to take your own mask off, that type of thing. Or if you're in a private individual's office. And then the only shall that we see in here, or our mandate, is on bus transportation. So the transportation section says, as school buses are owned, funded, and maintained by the South Carolina Department of Education, students and staff utilizing these buses for transport to and from school will be expected to adhere to the South Carolina Department of Education face covering guidelines for school buses. Face coverings are required for all staff, including bus drivers, faculty, students, and volunteers. These requirements will be enforced with disciplinary action as needed. The district will provide bus drivers with extra masks for those who need them in order to comply with the SCDOE regulations. And then another thing that I did not change was visitors. So non-essential visitors to district buildings will be limited in accordance with the administrative rule, and visitors include but are not limited to, parents, legal guardians, contract service providers, and delivery persons. And then it says visitors are required to wear a face covering while on district property. So that's the only mandate that we would put, and that would be something that is an absolute. There would be no choice for visitors. And then the important part would be, because I'm not sure we're upholding this really, but the important part about harassment and bullying is the district will not tolerate harassment of anyone wearing or not wearing face coverings. That had to add that in there. And will appropriately discipline students and staff or visitors who engage in behavior that interferes with any student or staff member's ability to comply with this policy. So those are the key changes or things that I chose to keep from the old policy too.
So if I understood you right, the only part that's changed is where it is staff members and students where you have strongly encouraged. Is that the only?
Right.
Otherwise, it's all the same wording? Because, I haven't read all the other policy.
Right, yeah, so the old policy said that staff members shall, which we were not really following because they were given options and choices, whereas the students aren't, so not all of them. So to me, that actually makes us more compliant with what we're currently doing with our staff members, is that we're encouraging them, but we're not making them wear them. And then the students are only encouraged to be worn, and then there's lots of exceptions that they are allowed to take them off in classrooms and social distancing, but they're still encouraged to do so.
Madam Chair, can I make one point of
Yes, yeah, I would love, yes. I was going to call on you right now.
Since the board repealed policy ADD, and
Yeah.
this would be a new policy ADD.
Right.
And y'all do have a policy that requires 2 readings of a policy. Y'all need to suspend that policy, the policy that calls for 2 readings before a policy is adopted, to ensure that an amended policy is legally effective under your own board policy. And I can look up and tell you what that policy number is, if you'll give me a minute, or somebody may have access to it pretty quickly. I don't know if Ms. Huddle can find that, but y'all do need to suspend that policy, because if you have to go through 2 readings, then Ms. Gardner's policy is going to have, no effect, because
With 28 days left. Yeah.
Right. So y'all just need to do that first before you vote on Ms. Gardner's
Okay.
new revised policy.
I had some questions about this before we get to it. Is that okay? Can we,
While she's looking it up?
I just wanted to ask, but I'll be last. You've got a question. Go ahead. I'll be last.
Well, I mean, before you go through that, what I would like to do is propose an amendment and simply propose the resolution that Andrea White drafted for this board, that she felt would comply with the immunity statute. It's not a full-blown policy. It simply plugs us into the state standards, and it says generally adhere. But I would like to make a motion, if my computer doesn't
Well, it'd have to be
go.
an amendment. We've got a
Yeah,
motion with a second.
I'd like to make a motion to amend it.
Okay.
And can I do that?
You can.
And then if people don't agree, then you can go on and do your second votes and all that. I mean, suspend that other policy. But I would rather what legal counsel proposed for us to address the issue we've been talking about. I'd rather propose that as an amendment.
Mr. White, I'm a little confused, since this is a motion that's written out, and then a second, and then I realize that we've got to amend our policy and for this to go in effect in one night. Is your amendment going to be?
To delete and replace her motion with this, and then you can vote it up or down. I'm trying to put hers ahead of you going through suspending that policy.
I see what you're saying, in case it's 4-3,
Yeah,
whatever,
I mean,
it's
at
5-2.
least y'all can see everybody knows what she, on the board, because she sent us the resolution, but the public will have the benefit of it. But this is the resolution that was prepared by our attorney, and the rest of us are looking at something we're never going to read before we vote on it tonight, even if we suspend it. I mean, we're not going to be able to absorb all that, but so my motion is to amend Ms. Gardner's motion by deleting it entirely and replace it with the following. Be it resolved as follows. Number 1, until the last day of the 2020-21 school year only, the district generally adhere to the guidelines for facial coverings adopted by the Department of Education and approved by the State Board of Education in August 2020. Number 2, the district will adhere to the guidelines by requiring that students, staff, and visitors to our school wear a face covering at the following times, in school hallways, in the cafeteria, and while riding school buses. Number 3, students and staff will not be required to wear a mask while outdoors. Number 4, teachers will have the discretion and are strongly encouraged to allow students to remove masks while in individual classrooms.
So that's your amendment is to replace her
Ms.
motion.
Gardner's motion and proposal about this policy with this motion to adopt this resolution prepared by our legal counsel to address the issue about compliance and having immunity.
But I have to get a second
I have
before
a
we can.
point of order. I'm not sure that you can amend a policy, you can amend a motion by
Or a policy.
removing it.
I
think
asked
you have to
Andrea White
have-
in the hallway, and she said I could.
Well, you can, I don't think we had, I'm not sure. I don't recall us having that specific discussion, because I think and I don't have Robert's Rules of Orders right here handy, but I think what you probably need to do, because you're replacing her entire motion, is to have a vote
On her motion.
on her motion
thought.
first, and then if her motion doesn't pass, yours will be on an alternative motion. Because I think that would, an amendment has to be directed to some part of the original motion, not entirely replacing it.
Yeah, I get it. Well, that was my question, Mr. White, because in my mind, amending hers was kind of would be adding to it or changing part of it. Yes, I
Well,
got you.
and another thing, Ms. Gardner, is as far as your original motion, you could make that as a resolution as opposed to making it a new policy and then not have to worry about suspending the policy that requires 2 readings before a policy is enacted. That's an alternative. But if you're going to make it a new policy ADD, then you do need to suspend your policy that requires 2 readings.
And we
So
need
you
to
could do it
put
either
that.
way.
Well, so
That
I need some
policy-
clarification, because I thought we needed a policy on this. That's what we're doing here.
There is a policy, BGD, that requires 2 readings, but you can suspend
Right, you
this
can
policy.
suspend that. Y'all have the
We
authority
can
under
vote to
another
suspend this
policy to suspend a policy. So I just, I just want to make sure that whatever you decide to do this evening, there's no question about the validity of how the board did it. Right, which is why I'm saying you need to, if you're going to have a new policy ADD, that you need to suspend the one that Ms. Huddle just read.
Yeah, do the resolution.
All right, well, I'd like to amend my motion
Okay.
to say that, I guess I just need to restate the whole thing. Okay. To reasonably adhere to state school board guidelines and to clarify District 5's position on masks, and to provide students, staff, and parents choice, I move that we adopt the resolution of the, do I have to read this whole thing, or do I have to?
No,
Just of the, I can't say
face
policy.
covering proposed.
Okay. Be it resolved, right. The policy of face, or the face covering guidelines that I distributed earlier.
But that's fine, as communicating to the rest of the board what your motion is, so that it's clear to everybody what it is they're voting on.
Right.
And will you clarify the resolution? How is it different from, how does it negate or the need to change the policy about 2 readings?
Because this would be resolving what the practice of the district, or clarifying what the practice of the district is going to be through the end of the 2021 school year. So she is doing it as a resolution, right, that the board will then have to vote on whether they agree to that or not. But doing it this way avoids y'all having to suspend the policy, what is it, Ms. Huddle, BC, that requires that
BGD.
you give 2 readings to a policy.
Jen, I got a question. Okay, does Ms. Gardner's resolution, would it apply to immunity just as the one that you wrote would?
It will, and again, I'm going to go back to what I said before. Whether or not there is, whether or not an entity is reasonably adhering to
Right.
public health guidelines, whether strongly encouraging is reasonably adhering to, as opposed to requiring, is a question that will ultimately be decided by, if you're sued, that would be decided by a judge or a
So,
jury.
I mean, what we're talking about here is the definition of how we would handle liability in regards to any suit. So while Ms. Gardner's attempting to do what is necessary, those words may not be strong enough or may not be the right words to adhere to the state.
That's correct.
Okay, I got you.
Did we get a second?
Yeah, she said, Ms. Hines seconded it, didn't you?
I think Ms. Hines.
Ms. Hines seconded, it, yes, and we've had discussion. So we will vote on this resolution.
We're
I'm
still in
sorry.
discussion,
Yeah,
though,
sure,
right?
yeah.
I think that, I mean, I'm not a lawyer, but to me, it sounds like it reasonably adheres. And I just kind of want to point out that the whole reason we're here, we weren't talking about masks 3 months ago. We're here because we have 2 students out of 17,000 with, that is .00012. So, ma'am? Oh, well, and they may be in the 5 program. So anyway, I just, I want to make the point, I have struggled with this a lot because I want to protect our school district, and we have to put children first. That would be difficult to do if we spent hundreds of thousands of dollars on general fund legal fees. But I feel that Ms. Gardner's proposed, her motion largely supports, and it reasonably adheres. So just want to put that view forward.
Okay. Are we ready to vote? I mean, no other questions? All right, all those in favor of the resolution, raise your hand. 1, 2, 3, 4, and 5. And those opposed? 2. So the resolution passes. So do we need to, now do we need to do anything like vote on it? That's going to be our policy? And I'm confused where you...
That's going to be the practice of the school district going forward for the remainder of the school year, and so that needs to be disseminated to your student, staff, and visitors.
So it's...
So that there's no question what the practice of the school district is going to be.
I got you. So, and it would go into effect tomorrow? I mean, we didn't have any date on that, did we? But it'll be immediately. Okay. So, there should be, the thing I'd like to say, my vote tonight does not necessarily indicate my conviction, but my vote was based on the South Carolina Department of Education and our legal obligations and any funds that we may have to spend to defend ourselves, even if we win it on our convictions. But I appreciate the board, appreciate the work of everyone, and Ms. White, we appreciate your being here, and I appreciate all the people that took their time to come and share their feelings with us, and I certainly hope that our children, either way, will continue to feel safe, and I do know, as a teacher, the different ways masks are really adhered to, and I don't in any way, again, my vote's not that I don't think that kids need the choice. I think mine was more about the legality and feeling like I did not protect the district when I know there are going to be lawsuits. So that was I need to say that to my constituents who know that I am a person that stands for freedom. So next on our agenda is, a 12, approval of sale of land parcel to SCDOT, Exhibit E. Mr. Beatonball, we appreciate you waiting on us for this late hour, but what we had to talk about was very important to this district.
Yes, ma'am. Thank you, Chair Hammond, board members, Dr. Melton. As you all are aware, South Carolina Department of Transportation is in the process of widening I-26 eastbound and westbound lanes. They have approached us about acquiring a small parcel of land, 0.155 acres, actually right down the street here, right on the other side of the barn. This will allow them to widen the road and also straighten the road to get ready for the widening of the road. So they have done an appraisal and have offered us $6,300 for that 0.155 acres of land to help them straighten the road and allow them to widen east and westbound lanes on I-26.
Any questions from the board? Any comments, any motions?
I'll make a motion.
You can.
Okay, I make a motion to approve the sale of land parcel to the SCDOT as discussed in Exhibit E which was .155 acres along Mount Vernon Church Road, as Mr. Beedenbaugh indicated.
Is there a second? Ms. Huddle seconds. Any discussion? Seeing none, all those in favor? And that's 7, no opposed. All right. Yes,
Unless the board needs me,
you've had a long night.
I've got an hour to drop things. So.
Thank you. We appreciate your being here so much, and I appreciate your
Y'all have a good evening. I appreciate it.
your legal expertise. Thank you.